Okay, let's unpack this. Have you ever had that moment, you're digging through old files, maybe trying to sort out your finances, and you find something, a reminder of a debt you thought was totally gone?
Yeah, like a collection notice from years back, or just that nagging memory of, an account you stopped paying on.
Exactly. And that feeling starts. That little worry, can they still come after me? Can a collector actually take me to court for something from like 5, 10 years ago? It's this uncertainty that really gets under your skin.
It does, and a lot of that anxiety comes from, well, not really being clear on how debt timelines work in the U.S. legal system. There are just so many misunderstandings out there about how long a collector really has the power to, legally force you to pay.
Right. That old debt, the one you figured was just a ghost story. It might still be out there, lurking, but maybe its power isn't what you think. So, for this deep dive, we've got a whole stack of your sources articles, research notes, even forum discussions to really get to the bottom of it. Can old debts really haunt you forever? And more importantly, how can you use this info to know your rights and protect yourself?
Yeah, our mission today is pretty clear. Cut through that fog, give you some solid, actionable knowledge. We'll look at the different clocks ticking on debt, what hits your credit report versus what lets them sue you.
And what collectors can and, crucially, can't legally do.
Exactly. And lay out some steps for what to do if you actually get that call or letter about an old debt.
Okay. And the first thing, the most critical distinction we absolutely need to nail down right away, it seems, is this. The timeline for a debt showing up on your credit report. That's totally different from the timeline for a collector being able to legally sue you in court over it.
Absolutely fundamental. They are not the same thing. People mix these up all the time, and that confusion can lead to some really big mistakes.
Yeah, I can see how you hear, it fell off my credit report, and you think, great, it's gone forever.
Right. But the sources are really clear. These are two separate tracks governed by different laws running on different schedules.
Okay, let's dive into segment 1 then and really pull these two timelines apart. No more confusion.
Sounds good. It's funny how that 7-year rule is so well known, isn't it? That's the one most people latch onto.
It is. It's like the main number people associate with old debt. So that's our first timeline. Credit reporting. Our sources, CBS News, Reddit threads, Consumer Law Group, Bankrate, they all point to this common 7-year mark. What they're saying is most negative stuff on your credit report.
Yeah, like late payments, collection accounts, charge-offs, that sort of thing.
Right. Those generally have to be removed from your reports with the big bureaus, Equifax, Experian, TransUnion, after about 7 years.
And the key is when that 7-year clock starts. It's usually from the date of the original delinquency. So the first time you miss that payment that eventually led to the whole mess, the default, the collection account, that's often day 1 for the 7-year countdown.
Okay, so from that first missed payment, once 7 years pass from that point, the negative mark should just vanish from your report.
It should fall off, yeah. That's the term people use. Once it's gone, it shouldn't show up on standard credit reports anymore.
The practical effect, your credit score.
Well, it should stop hurting your score, at least for that specific item. It's no longer being factored into the calculations for, your FICO score. Lenders pulling your report just shouldn't see it anymore. It becomes kind of invisible to them.
Got it. And this whole 7-year thing, it's driven by federal law, right? The Fair Credit Reporting Act, the FCRA.
Exactly. The FCRA governs credit reporting. And one thing the FCRA specifically prevents is something called re-aging.
Re-aging? What's that?
It's basically an illegal trick where a collector tries to make an old debt look newer on your credit report. Maybe they report some recent activity, trying to reset that 7-year clock. The FCRA says, no, the clock starts from the original problem date, not some later collection shuffle. It's all about limiting how long old mistakes haunt your credit history.
Okay, so FCRA, 7 years, credit report, credit score. That's one track.
Yeah.
But, and this is the big but everyone needs to hear, this 7-year credit reporting limit has absolutely nothing to do with whether a collector can legally sue you to force payment.
That's the crucial disconnect. Just because it's off your credit report doesn't mean you're safe from a lawsuit. They're completely separate issues. Your ability to get a new loan isn't the same thing as a collector's ability to, say, garnish your wages through a court order.
Okay, so that brings us to the second timeline, the legal one, the statute of limitations.
Right, the SOL. And this one is about legal action. It's a hard deadline set by law.
But not federal law this time.
No, crucially, the SOL is set by state law. Each state decides for itself how long a creditor or debt collector has to file an actual lawsuit against you to collect a particular type of debt.
And a lawsuit is how they legally force payment, right? Like wage garnishment or freezing bank accounts.
Exactly. Filing a suit is the step they need to take to get a court judgment, which then unlocks those more serious collection tools. Without a judgment, they can ask you to pay, but they can't usually force the issue legally.
Okay, so unlike the fairly standard 7-year credit reporting rule, this SOL thing is different everywhere. That sounds complicated.
It really is. It varies hugely, not just by state, but also by the type of debt we're talking about. All the sources hammer this point home.
So what's typical? Is there even a typical range?
Well, you often see ranges like 3 to 6 years mentioned for common things like credit card debt or personal loans, but that's just a rough guide.
It could be shorter or longer.
Oh yeah, much shorter or much longer. Some states might have only a 2 or 3 year SOL for certain debts. Others, you could be looking at 10, 15, even 20 years for things like written contracts, mortgages, or maybe existing court judgments, depending on that specific state's laws.
Wow.
Yeah, like one source mentioned Virginia has a 5-year SOL for written contracts, but only 3 years if it was just a verbal agreement or unsigned. And sometimes there's even a 4-year limit for debts related to selling goods that might override other rules.
And private student loans, they have SOLs too. I thought student loans were different.
Private student loans generally do, yes, unlike most federal loans. And those state SOLs for private loans can also vary a lot, maybe 3 to 10 years.
Okay, so the type of debt, written versus verbal, and the specific state, that's a lot of variables compared to the 7-year rule.
It definitely requires more digging into your specific situation. So just to recap this first bit, you've got the 7-year FCRA rule for your credit report, and then the state-by-state SOL, which dictates the deadline for lawsuits. Totally separate clocks, different laws, different consequences.
Got it. Understanding that split is huge. Because when that legal SOL clock runs out, the debt changes status, right? It becomes, what's the term?
Time barred. That's the key term. Segment 2, understanding time barred debt.
Okay, time barred. What does that mean exactly?
It means the statute of limitations for that debt, according to the relevant state law, has officially expired. The window for the collector to successfully sue you in court has closed. That's the core definition from sources like CBS News, Bankrate, Solo Suit.
So if they did try to sue you after the SOL was up,
You'd have a solid legal defense. It's called the time-barred defense.
Yep.
If you get sued, you absolutely have to show up or file a response with the court and raise this defense. You'd basically say, hey, the deadline to sue me passed before you even filed this case. You might need to show some proof about the debt's age.
and if the court agrees.
The case should be dismissed. The collector loses their legal standing to pursue that lawsuit.
Okay, so they can't sue you. Does that mean the debt is just, poof, gone, wiped clean?
And here's another really common and kind of dangerous misunderstanding. The sources are super clear on this. Time barred does not mean the debt disappears.
Wait, really?
Yeah. It doesn't mean it's forgiven. You still technically owe the money.
Hold on. How can you still owe it if they can't sue you for it? What does technically owe mean here?
It's a bit confusing, I know. Think of it like this. You received the service or the loan or whatever it was, and you didn't fully pay it back. So the original obligation, maybe a moral one or just the record of it, still exists. What's gone is the legal mechanism to force you to pay through the court system if you raise that time-barred defense. Solo Suit explicitly says it's not debt forgiveness.
Okay, that is a subtle but really important difference. The debt exists, but their main weapon, the lawsuit, is disabled. So if they can't sue, what can they still do? Can they just keep calling me forever?
And this is where it gets uncomfortable for people and leads right into this idea of zombie debt. Even if the SOL has expired, collectors can still try to collect. Yeah, they can still contact you, calls, letters, emails, trying to persuade you to pay voluntarily. They haven't lost the right to ask for the money or try to negotiate a settlement.
So the key is they lose the lawsuit threat, but not necessarily the ability to communicate and ask for payment.
Pretty much. Their most powerful legal tool is off the table, assuming you defend yourself correctly if sued. But just asking you to pay, that's often still allowed as long as they follow other rules, like the FDCPA, which we'll get into.
Right. Okay, zombie debt.
Okay.
That term keeps popping up. It's pretty vivid, isn't it? Old debts rising from the grave.
It really paints a picture. It describes these old, often expired debts where the SOLs likely run out that collectors buy up, usually for super cheap, and then they try to revive them and collect, even though they probably can't win a lawsuit if challenged.
But why bother? If they know they can't sue successfully, what's the point?
It's a business model, really, a numbers game. These agencies buy massive portfolios of old, defaulted debt for pennies on the dollar. Literally, sometimes just a tiny fraction of what was originally owed. Their bet is that if they contact enough people, some debtors will pay something. Maybe out of guilt, maybe confusion, maybe they don't know about the SOL, or maybe they just get pressured into it. Because the collector bought the debt so cheaply, even getting small payments from a fraction of people can turn a big profit.
Wow. So they're banking on people not knowing their rights or falling for certain tactics. What kind of debts usually become zombie debt?
The usual suspects, really. Old credit card balances, medical bills that went to collections, unpaid personal loans, old utility bills, sometimes even old court judgments where the enforcement period expired, things like that. Very common types of consumer debt.
It definitely sounds like it could be predatory, especially if they're actively trying to collect on something they know is legally unenforceable through the courts.
And that leads us right into the biggest risk here, the core of segment 3. You can accidentally bring that debt back from the dead. You can restart the clock.
Okay, this sounds like the really crucial part. Restarting the statute of limitations clock. How does that even happen? All the sources seem to warn about this.
It's the major pitfall. Certain actions you take, things that might seem small or even like a good gesture, can legally reset the SOL in many states. It's like giving the debt a brand new life, wiping out your time-barred defense.
So the debt goes from being legally uncollectible via lawsuit back to being fully collectible again.
Potentially, yes. It's a huge risk. The collector suddenly might regain the right to sue you, garnish wages, all the things they couldn't do before.
Okay, so what are these dangerous actions? What absolutely must you avoid doing if you're contacted about an old debt you think might be time-barred?
The number one thing, cited everywhere, CBS News, solo suit, OK Law, bank rate, is making a payment. Even a tiny payment.
Seriously, like sending them $5?
Yes. In many states, making any payment, no matter how small, can be legally interpreted as acknowledging the debt and restarting the SOL from the date of that payment. Collectors sometimes push for a good faith payment. For exactly this reason, it's a tactic to revive the debt's legal status.
That feels incredibly sneaky if they know that little payment gives them back the power to sue for the full amount.
It highlights the incentive structure, right? Other actions that can restart the clock, according to sources like Solo Suit and OK Law, include acknowledging the debt is yours.
Just acknowledging it, like saying on the phone, oh yeah, I remember that old bill, things were tough back then. That could reset the SOL.
In many states, yes. A clear acknowledgement that the debt is valid and yours can be seen by a court as reaffirming the obligation, resetting the clock. Promising to pay can also do it.
Making a payment, acknowledging the debt, promising to pay, these sound like exactly the things a collector would try to get you to do or say.
Absolutely. They might specifically try to trick or pressure you into one of these actions precisely because they know it could revive their ability to sue. They bought the debt cheap, they can't sue now, but get you to pay $10 or admit you owe it, and bam, they might have a legally enforceable claim again.
That's a huge incentive for them to be persistent, maybe even misleading. Makes being careful essential. And you mentioned earlier that even figuring out the original SOL start date can be fuzzy sometimes.
Yeah, that adds another layer of complexity. When did the clock actually start? Was it the date of your last payment? The date the original creditor charged it off? When the collection agency bought it? State laws can differ, and the original contract terms matter. It makes it hard for you, the consumer, to be absolutely certain if it is time-barred without really digging in.
Which underlines the need to verify everything. What about moving states? Does the SOL change if you move?
Ah, that's tricky. It often depends on the original contract. Did it specify which state's law applies? It might be the law of the state where you incurred the debt, even if you live somewhere else now. That's definitely lawyer territory to figure out for sure.
Okay, so the huge flashing warning sign from segment 3 is, if you think a debt might be time-barred, be extremely careful. Don't pay anything. Don't admit you owe it. Don't promise to pay. Any of those could restart the SOL and let them sue you again.
That's the core defense against zombie debt revival tactics. But thankfully, you're not totally defenseless against aggressive collectors. Which brings us to segment 4. Your shield. The Fair Debt Collection Practices Act, or FDCPA.
The FDCPA. Sounds like the cavalry coming over the hill. This is a federal law, right?
Yeah.
Meant to protect people.
Exactly. Its whole purpose, straight from the FTC, is to stop abusive debt collection practices. It sets rules for how collectors have to behave. No harassment, no lies, no unfair tricks when they're trying to collect consumer debts.
Okay, who does it apply to? Any company trying to collect.
Primarily, it applies to debt collectors, which the law generally defines as third parties collecting debts owed to someone else.
So not necessarily the original company I owed money to, like my credit card bank.
Often no. If the original creditor, like Chase or whoever, is collecting its own debt in its own name, they might not be covered by the FDCPA itself, though other laws still apply to them. But the moment they sell that debt to XYZ Collections, Inc., that company, the third-party collector or debt buyer, is definitely covered by the FDCTA. That's who the law mainly targets.
Got it. So if it's a collection agency calling about an old debt, the FDCPA is my protection. What kind of nasty stuff does it specifically forbid, especially things relevant to these old, potentially time-barred debts?
Well, lots of things. Under harassment, they can't call you over and over just to annoy you. They can't use obscene language. They can't publish your name on a deadbeat list. And generally, no calls before 8 a.m. or after 9 p.m. your local time.
Okay, basic decency rules. What about lying or misleading you? That seems super relevant here.
Huge. They cannot misrepresent the character, amount, or legal status of the debt. Claiming they can sue you on a time-barred debt, that's misrepresenting its legal status. Big FDCPA violation. They also can't threaten actions they can't legally take or don't intend to take, like threatening arrest for consumer debt, which is almost never legal, or saying they'll seize your property if they don't have a court order allowing it.
So empty threats like pay up or we'll have you arrested or we're taking your car tomorrow are illegal if they're not actually legally possible.
Exactly. They also can't falsely imply non-payment is a crime, pretend to be lawyers or government agents, or send documents that look like official court papers but aren't. And a key thing, they must disclose in communications that they are a debt collector trying to collect a debt.
That covers a lot of ground regarding deception. What about just plain unfair practices?
Yeah, they can't try to collect extra fees or interest that weren't in the original agreement or allowed by law. They can't use postcards to communicate about the debt because that reveals private info. And they can't put language on an envelope other than their name that screams debt collection.
So no postcards demanding payment, no envelopes with final warnings stamped on them.
Correct. And critically, circling back to time-barred debt, suing, or even just threatening to sue on a debt they know or should know is time-barred can itself be an FDCPA violation.
Well, wait. Just threatening to sue on an expired debt is potentially illegal under the FDCPA, even if they don't actually file.
Yes, because doing so misrepresents the legal status and implies they could win, which is deceptive if they know the SOL is up. And another important point, if you ask them directly, is this debt time-barred? They have to answer truthfully. They can't lie about it.
It's incredibly useful. A direct question they have to answer honestly. So the FDCPA is a really strong shield against many of the tactics used, especially with these older zombie debts.
It gives you a set of rights you really need to know about. Knowing the rules empowers you to spot violations and push back, which leads right into segment 5. Okay, what do you actually do? Step-by-step guide if you're contacted.
Let's start with the scariest scenario first.
Yeah.
You actually get sued. Court papers arrive. What's the absolute first thing?
Do not ignore it, ever. Even if you're 100% sure the debt is ancient and time-barred, ignoring a lawsuit is like handing them a win.
Why? What happens if you just toss it?
You'll almost certainly get hit with a default judgment. That's a court order saying you owe the money. And that judgment gives the collector real power. Wage garnishment, bank levies, property lands. Even if the original debt was time-barred, the judgment creates a new legal obligation, often with its own very long SOL. You lose your chance to defend yourself.
Okay, so job 1 is don't ignore it. Then what? Verify it's real.
Yeah, check for a case number, court name, maybe call the court clerk to confirm it's a legitimate filing. But once confirmed, take it very seriously.
And if you believe it's time-barred, you need to respond and use that defense.
Exactly. You have to file an answer with the court by the deadline, stating your defense is primarily that the statute of limitations expired before they sued. You'll likely need to show up in court, present your case. If the judge agrees the SOL was up, the lawsuit should be dismissed.
Okay, crucial advice for lawsuits. Now, what about the more common thing, just getting calls or letters about an old debt, but no lawsuit yet?
First step, always. Verify the debt. Don't just take the collector's word. Is it really yours? Is the amount right? Does it match any records you have?
How do you verify it officially using your rights?
You demand a written debt validation notice. Under the FDCPA, if they contact you, they have to send you this written notice within 5 days of that first contact, unless they gave you all the required info right then.
And what info has to be in that notice?
It needs to state the amount owed, the name of the creditor they claim you owe now, and crucially, it must tell you about your right to dispute the debt within 30 days of receiving the notice.
Ah, the 30-day dispute window. That sounds important.
Very. You have 30 days after getting that notice to send them a written dispute. You can say you don't owe it, the amount is wrong, whatever your reason is. Writing is key here. It creates proof and triggers more protections.
What happens once you send that written dispute within the 30 days?
This is powerful. The collector must stop all collection efforts against you. No more calls, no more letters trying to collect. They have to pause until they obtain verification of the debt, like proof you owe it, maybe the original contract, and mail that verification to you.
Wow. So sending that letter buys you time and forces them to prove their case.
Exactly. It pauses the pressure while you investigate. Send it certified mail so you have proof they got it.
Okay, so you get the validation, maybe dispute it, get their verification back. Then what?
Then you take all that info, plus your own records, and you figure out your state's statute of limitations for that specific debt type. Use online resources, maybe call a legal aid group, determine if it's actually time-barred.
And if your research shows it is time-barred.
Then we hammer home that point from earlier. Do not make any payment. Do not acknowledge the debt is yours. Do not promise to pay. Stand firm on that to avoid restarting the clock.
It sounds simple, but I bet it's hard when a collector's pressuring you.
It takes resolve, which leads to the next step. If you just want them to stop bothering you altogether.
Can you do that? Make them stop calling.
Yes. Under the FDCPA, you can send them a written cease communications letter. Tell them clearly, in writing, to stop contacting you about this debt.
Send it certified mail again, I assume.
Absolutely. Get that proof of receipt. Once they get that letter, they can basically only contact you again to say they're stopping collection efforts or to tell you they're taking specific legal action, like filing a suit, which, again, they shouldn't win if it's time-barred and you defend it.
So you can shut down the communication. What if they ignore that? Or violate the FDCPA in other ways? Harassment, illegal threats.
Report them. File complaints with the Federal Trade Commission, FTC, and the Consumer Financial Protection Bureau, CFPB. Both are key agencies. Also report them to your state attorney general's office.
Does reporting actually do anything? Can you fight back?
You might be able to sue them. The FDCPA allows consumers to sue collectors for violations. If you win, you could get actual damages, plus statutory damages up to $1,000, and they might have to pay your attorney fees. So yeah, the law has teeth.
Okay, so FDCPA violations can lead to consequences for the collector. But this all sounds pretty complex, especially the legal parts.
It can be. Which is why, if you're feeling overwhelmed, or especially if you're facing a lawsuit, getting professional help is often a really good idea.
Like talking to a financial advisor, or maybe even a lawyer who specializes in this stuff.
Exactly. A consumer law attorney, particularly one focused on debt defense, can really help navigate this. They know the state laws, the FDCPA rules, how to respond to lawsuits, how to deal with collectors. There are organizations like the National Association of Consumer Advocates, NACA, that can help you find one. It's often money well spent when you're dealing with potential judgments.
That makes a lot of sense. Okay, before we wrap up, let's quickly hit segment 6. Any specific nuances for different debt types?
Just a few quick points from the sources. For credit cards, remember the SOL varies by state. 3-10 years is common. And there can sometimes be legal arguments about whether a written or verbal contract SOL applies, especially if they can't produce the original agreement. That's lawyer territory.
Okay, medical debt.
It has state SOLs like other debts, but the credit bureaus now treat it a bit differently. It weighs less heavily on your credit score than it used to, which is helpful. Doesn't change the collection rules, though.
Good to know. And private student loans.
Key thing. Private loans generally do have state SOLs, unlike most federal loans. Again, the time frame varies by state, maybe 3-10 years. Defaulting still has serious consequences, potential lawsuits within the SOL, credit damage, etc., but the SOL does apply.
Right, crucial distinction between private and federal. Federal loans are a whole different ballgame, not covered here.
Exactly. Know which type you have.
Okay, this has been incredibly clarifying. We've gone from that vague fear of old debts to some really concrete rules and actions. Let's try to boil it down.
Sure. The big picture. The 7-year credit reporting timeline is separate from the state-specific statute of limitations for lawsuits. One expiring doesn't automatically mean the other has.
Time-barred debt means the lawsuit clock the SOL has run out. They can't successfully sue you if you raise that defense in court. But the debt doesn't magically disappear, and they can still ask you to pay.
And the absolute danger zone. accidentally restarting that SOL clock, making a payment, acknowledging the debt, promising to pay any of these can potentially bring a time-barred debt back to life legally in many states. Be incredibly cautious.
Your shield is the FDCPA Fair Debt Collection Practices Act. It bans harassment, lies, like false threats or misrepresenting the debt's legal status, and unfair tactics. Know your rights under this law.
If contacted, verify the debt, demand written validation, check your state's SOL, dispute in writing within 30 days to pause collection. If it's time-barred, don't do anything to restart the clock. Send a cease communication letter if needed.
And never, ever ignore a lawsuit. Respond. Defend yourself using the time-barred defense if it applies. Report FDCPA violations to the FTC, CFPB, and state AG. Consider suing the collector if they break the law.
And don't hesitate to get professional help, especially from a consumer law attorney if things get serious or confusing.
The core lesson from all this seems to be about the power of being informed and proactive. You don't have to be a victim to zombie debt collectors. Understanding the rules, verification, SOLs, FDCPA, cautious communication is how you protect yourself.
Knowledge really is your best defense here.
Which leads us to maybe a final thought to chew on. Think about how easily an old, legally uncollectible debt can be revived. Just a small payment, a few words acknowledging it, and suddenly it's a real legal threat again. What does that fragility tell us about financial risk? About the need to be vigilant and informed in all our financial dealings, even ones that feel ancient or minor? How might knowing this vulnerability change how you react the next time you get an unexpected call or letter about money?
It really drives home that staying aware is fundamental to financial health, even concerning the past.
Use this knowledge, stay informed, and seek help if you need it. This has been The Deep Dive. We'll catch you on the next one.